first like to welcome you all on behalf of all the trustees of the Foundation of International Tax. And we have the person actually who authored that judgment called the Azadi Bachao Andolan, which I felt was the judgment, is the judgment today, which serves the treaty interpretation principles. So it's a privilege and honor to welcome Honorable Justice B.N. Srikrishna, who along with Honorable Justice Rumapal was actually the people who authored the order.
So I was just thinking about revisiting Azadi Bachao. You know, in the good old days when penicillin was discovered, whatever your problem, the doctor would say, take penicillin, it will get cured. I'm afraid that is not true neither in the medical field nor in the legal field. A Supreme Court judgment must be examined for what it is, and the ratio of that has to be applied to the case on hand by the High Court or the other authorities below. Now, I was told that Azadi has been waived as if it's a trump card which will beat all. Two of them were judgments of the Delhi High Court. I got extracts of the Delhi High Court judgment. One was in Blackstone, the other is the judgment in, I think, Concentrics. It's headed as Opium or Optum Global Solution International. How interpretation of treaties should be done by domestic fora also in the manner in which the application of the treaty applied to the local courts and the local citizens. Now, in this case, an argument was made that the treaty had to be interpreted in a particular manner, and a passage in Francis Binion on interpretation of treaties was put forward. And I noticed that 2 pages thereafter, there was a long passage which in effect said, this is actually quoting from Justice Wilberforce of the, I think, House of Lords in England, saying that treaties are intended for many purposes. A treaty is not necessarily confined to one limited issue, and it cannot be interpreted like a statute of parliament or a circular issued by the delegate of parliament. And what happens is that treaties are negotiated by diplomats who deliberately keep various other objectives in mind, and with that sometimes they vaguely keep the language somewhat flexible so that depending on the circumstances it can be readjusted or adjusted. Now, this is all that the passage said. Now, that doesn't mean that you can pick up that, and that is not really the crux or the turning point. What the Supreme Court said must be analyzed and then applied only if applicable. Now, the Supreme Court has never said that this is the law as far as all treaties are concerned, this is the law as far as all circulars under 119 are concerned. The Supreme Court was focusing its attention on one particular issue, namely whether the circular 789 was valid or invalid. And in the context of that, because an argument was made about treaty interpretation, and a passage from Francis Binion was quoted. That is not the crux of the law as far as the judgment is concerned. That is why I said, no judge of the country is required to switch off his mind the moment you show him a Supreme Court judgment. No, he is supposed to keep his mind open, read it and see if it applies. Now, the only question is, if the treaty permits you to take advantage of a situation, for heaven's sake, what is wrong in that? It's not an immoral thing, it is not something that Bible has prescribed or the Upanishads or the Bhagavad Gita has said, don't do tea shopping. No, there is nothing immoral about it. The question is, does it lend itself to a situation where a person who is not really intended to be a party to the two contracting states gets a benefit? Hey, treaty shopping is bad, therefore everything is bad, is not the way you read the judgment of the Supreme Court at all. That is not what Azadi Bachao said. Azadi Bachao said, hey look, treaties are concluded on the basis of not only the tax point, but also on various other incidental circumstances, incidental inputs, and therefore you have to look at all that before you make up your mind and interpret the treaty. In respect of tax treaties, Section 90 made a specific provision. Section 90 said that the executive shall have the right to implement the treaty and also notify that the treaty has been effected. The moment the treaty had been signed, the results of the treaty are automatically available in the country as a result of the notification itself. There is no further notification required that the treaty benefits has to be extended or not extended or anything of that. 90 makes it clear that it is intended to operate in deviation of the law itself. Otherwise, there is no point in having. One more core issue in the Supreme Court judgment in Azadi Bachao is the validity of the principle laid down in Westminster case. Supreme Court called it a hiccup. The hiccup in the history. Why is it a hiccup? Because McDowell, technically speaking, is a judgment of 5 judges. Supreme Court called it a hiccup. The hiccup in the history. Why is it a hiccup? Because McDowell, technically speaking, is a judgment of 5 judges bench. 4 judges re-echo the principle in Westminster and say that a citizen can arrange his or her affairs in such manner that the least amount of tax incidence happens. Justice Chinnappa Reddy, the 5th one, goes into a long history of what is there. Then he says tax avoidance is as bad as tax evasion, and then he says it is time that it should be all over England it has been given up, etc., etc., etc. So when this was examined, it was pointed out that look, even in England the principle of Westminster has not been departed. So many other judgments were cited. It was also pointed out that 4 of the learned judges have repeatedly echoed the whole thing, but in the passing they have said, oh, we agree with Justice Chinnappa Reddy's judgment. Therefore, that doesn't really mean that it is the core issue of the judgment at all. And then it was also pointed out that there was an earlier Constitution bench judgment of our own Supreme Court agreeing with the principle in Westminster and saying that this is the correct way of interpretation of tax in tax jurisdiction. So if that was so, then obviously McDowell was a hiccup. I can't use a stronger word because I'll be committing contempt of court. It was a hiccup, and the hiccup had to be naturally cured by giving a strong dose of medicine, which what Azadi Bachao has really done. So that was the core issue. Now, unfortunately, the judgment is being used for other purposes, which I think is not justified. Please, therefore, it's possible that in today's context, things may be different. In fact, I have always said, with this GAR principle overtaking us all over the world, including in India, what is GAR? GAR is, it gives the authority to the income tax assessing authority at whatever level to look through a scheme or a design and nullify its effect if he comes to the conclusion that it was intended specifically to avoid tax. I always say this, and of course it is not seriously intended. I am 83 years old, and tomorrow I might get tired and say, hey, I don't want to practice law at all in whatever manner I practice. I want to sit at home and play with my grandchildren. Now, it might happen that in the years, past so many years, even after retirement from the Supreme Court, I have paid crores of rupees as tax to the income tax authorities. The income tax assessing authority will say, hey, the reason why you gave up practice is to defeat the amount of income tax that you would have paid otherwise to the government of India. Therefore, either you continue to practice or continue to pay whatever you are paying the last payment that you made. Now, perhaps GAR can be extended to that extent, and I am sure that there are cleverer people, intelligent people in this country, in the courts and outside the courts, who will not allow such things to happen. What is really objectionable is that, in fact, the House of Lords has said when they used the word device, they said we are not using it in a pejorative manner. We are saying that the device is the stratagem. If the stratagem has not achieved the purpose for which it was, we cannot say that the purpose that for which it was designed has been achieved or not.
So please join me in thanking Honorable. We couldn't have asked for a better way to start our conference. Thank you very much, sir, for coming and blessing us. And we are indeed